to you, Councillor Osnegan.
Thank you, Chair. Chair, the question is, why are we here? We are here because Snengani, on the 30th of January 2025, has filed a complaint. Then the question is, in addition to why we are here, what is the basis of the complaint? The basis of the complaint is that the second respondent, together with the fourth respondent, have appointed, or the other one failed to appoint, and then delegated the powers to the other, who appointed the third respondent in a match where he was directly or indirectly connected to one of the participating team, and who also approved the list that was submitted on him as a referees committee. That's the reason we're here. This complaint has been filed in terms of Rule 19.1. And I think it's important that I read what is provided under Rule 19.1 in order to dispel any mischaracterization of our case. 19.1 says, a team that has not lodged a protest in respect of a game in which it participated may lodge a complaint with the league in respect of any act of misconduct, offences allegedly committed. No third-party complaint shall be accepted. A complaint has been filed in terms of Rule 19.1, which was compliant, and the alleged offense or misconduct that has been committed. Under Rule 24, it's a definition of a misconduct, but in particular, the one that is in question, you'll find it under Rule 31. Under Rule 31, it provides the Chief Executive Officer or the designated SAFA official will appoint match commissioners, open brackets, who shall not be connected directly or indirectly to any participating team, and close brackets, from a list to be approved by the relevant referees committee from time to time for a specific games. I think if we look at what is provided under that rule, we will see that there are three operating words that are being used. There will be a Chief Executive Officer or designated SAFA official who will make the appointment. That's the first part. Then the second part will be the match commissioner who shall not be directly or indirectly connected to the participating team. That's the second process. Then the third process is the list to be approved by the relevant referees committee from time to time. That's the nature of the complaint. Then what also arises, having considered what is presented under 19 point 1 and what is being alleged to have been committed. A complaint is filed. We appear before the forum. Fortunately or unfortunately, we appear after having appeared in the High Court. Papers were filed in the High Court. Judgment was delivered in the High Court. And that judgment has not been reviewed or appealed or set aside. The judgment stands. Then the question is, based on what has been led today and what was failed to be challenged by the respondents, whether the case of the applicant has changed or the case remain the same. Without any doubt, the case of Snengane has not been challenged. It stands. Because if one can ask, why are the respondents before the forum today? What have they done? They just came here to say nothing. What is their case? We don't know. What have they presented to be their case? We don't know. But what we know as a matter of fact, based on the papers that are before you, which I must also dispel what has been said to say whatever we presented, it was a hearsay evidence. We know affidavits are not hearsay, are evidence. That submission, it's wrong in law. You don't say an affidavit that is before court, it's a hearsay. It's not a hearsay, it's evidence. Then if we look at what was presented in the High Court in relation to how the applicant presented his case insofar as the allegations are concerned. He says the appointment was incorrect because it was made by someone who was not designated in terms of 30.1. The appointment was defective because the person who was supposed to exercise that power did not exercise the power. That was the evidence that he gave on record. Then he says the acceptance of the appointment was defective in that the third respondent was, whether directly or indirectly, but connected with Ravens in that his son was playing for that team. And on the day in question, as it appears on the team list, he played. It's there on the team list under number 18. Then in addition to that, it's also stated in the founding affidavit under paragraph 5 that the third respondent is not only a match commissioner, he's a vice president, he's a head of referees. Then you look at what was said in the answering affidavit that was filed in the High Court. It's noted. We know it's tried law that when you note an allegation, it's good as admitting. I also take with dismay what has been said to now appear to distance from the affidavits that were filed in the High Court. We really take a serious issue. You cannot file affidavits in court, be present in court, a judgment is given, then when you appear before the DC because you want to present a different case or you want to confuse the commissioner, you come and say, actually, this is not my affidavit. Do we have a third respondent as a witness before this forum? No. Is there any witness that has been called to present evidence in respect of the respondents? No. Then again, if we look at the affidavits that were filed in the High Court, allegations have been set out, bases in which allegations are made that Rule 30 have been violated are clearly stated, they are not denied, in fact they are admitted. Then you ask, on what basis are you going to say there is no contravention in terms of Rule 31? There is none. There is only one version before you, which is the version of Snengane, and that version has not been tested. Mr. Cele tried, but unfortunately there is nothing that he could do. And there is nothing that was done to discredit the testimony of Snengane's chairman. Then if we look at what has been presented by Snengane in relation to what Snengane was required to prove, Snengane has proved that there is a violation in terms of Rule 31. The complaint, it is in compliance with Rule 19.1. It was also incorrect to make a reference to Rule 24, because that is just a definition of the misconduct and offenses. But it doesn't mean what is provided under Rule 30 is excluded. In fact, our complaint, it's clear that it's a complaint in terms of 19 where we allege that Rule 30 has been violated. You don't even have to go to town and go to Rule 24. There is no need. That rule, it's not applicable. And this is a serious issue about SAFA, because SAFA has to know their rules. It's similar to what is provided on the letter that was set aside by the High Court, where incorrect rules that were not applicable in the matter were referred. Again, like what was asked under cross-examination, which we objected as to why Snengane is asking for forfeiture. We are not being creative lawyers when we say the points should be forfeited. It's provided in the rules. It's part of the sanctions that should be ordered. And an appropriate sanction on this one, as we have demonstrated that the person who was appointed was not supposed to, the person who was appointing was not supposed to appoint. The person who was supposed to appoint did not appoint. The person who accepted the appointment was not a suitable candidate. The person who approved the referees list was not a suitable candidate. So it's a clear violation of Rule 30 in all respects. So in closing, we submit that Rule 30 has been violated. Then the question is, what should follow now that we have made a case and our case has not been challenged? Then to find the answer and to show that, again, we are not being creative lawyers, but we follow SAFA rules. And this case should be clear that Snengane is not coming here because we are crying babies, we ask points that we are not entitled to get, but we say because the game was unfair, the rule was violated, then my apologies, there is just one thing that I'm being pointed. My apologies about that, Chair. That disturbed my line of argument. But what I'm looking at, I want to go to 19.11.1, which are the competent sanctions to be ordered. As I was saying, we are not coming before this forum and ask that Snengane be given points in a game where they lost. But we are coming here to show a clear violation of the rule, which constitutes the game in its entirety to be unfair. You'll know, Commissioner, that in cases, I'll make an example about conferences where credentials are in question, and it's proved that some of the delegates that would have participated in that conference were not entitled to participate. We've seen in a number of cases from the High Court, from the SCA, and from the Concord. But where it's proven that some of the candidates have violated the rules, the entire conference will be declared null and void. And that is the basis as to why a forfeiture of the points is necessary. Because now that we have proven that the game, how the game started was unfair, there was a violation of the rule, we cannot say the game should remain as if everything was done properly. And it's clear even on the rule that not because Snengane is the complaining party must be given those points, but each team that participated must not get the points. Points must be forfeited. Then it says under 1911, the hearing of any charges instituted by SAFA in terms of Rule 19.8 shall be heard by the relevant SAFA disciplinary committee in accordance with the SAFA constitution and these rules and regulations, except that any sentence imposed by the disciplinary committee shall be limited to the following sentences or combination of the sentences. We are not only asking for one sentence to be imposed, but we are asking for the combination of all, because we believe, as we have demonstrated on our evidence, that it is competent for this forum to order all what is provided under 1911.1 that says impose of any monetary fine not exceeding 20,000. 1911.2, the censure of offending party concerned. 1911.3, the closure of ground for a stated period. 1911.4, ordering the offending party to pay all expenses of and incidental to the consideration of the matter. That goes to what Mr. Cela was saying, to say he should not be ordered to pay the costs. It's here. Should we succeed, Snengane is entitled to be awarded costs. It's part of what we should order. 1911.5, suspension of individual players or officials. And in this matter, it's a matter that involves the officials. Must be suspended, so that this misconduct that they have committed, they don't do it again. And I think, Chair, you will remember when Chairman of Snengane was giving evidence, alluding to the fact that one of the things that will have to be seriously considered as to how many matches Mr. Mbangata acted as a match commissioner where his son was playing, which is something that has to be stopped. Because even how they presented the case in trying to dispel what Snengane is saying, to say no, what happened during the game, that's not the test, that's not what has to be proven. He must understand that what is wrong about what he has done was to accept an appointment where he is ethically bound to reject it because his son is playing for the other team. It does not go to an extent of what happened during the game, but it's only limited about when he accepted the appointment. And that's the case that is before you. Then 1911.6, recommend to the competition committee the cancellation or expulsion or suspension of a team from the SAFA League competitions for any period. In this or her case, all results involving the expelled team will be expunged from the SAFA League competition as if the team had never played any matches. The barring of the offending party from entering the relevant SAFA League competition in the following season, forfeiture of points without awarding them to the complainant or any other team directly or indirectly affected by the misconduct. Chair, if we may just do check and balances in terms of what will be applicable to the present matter. It's 19.1, 1911.1, 1911.2, 1911.4, 1911.5, and 19.11.8. Chair, those will be our closing